and it got to the police. Even though the partner said doesn't want to proceed with charges, with anything, the police said they've seek advice from CPS, and CPS has made a decision to go ahead. They've made a decision to go with prosecuting the partner, and a firm is asking for a start of £10,000 deposit because they don't know how long the case will take. So plus or minus, they could refund, or the person has to add up to the legal fee at the end of the case. So it's better. Prevention is always better than cure. Prevention is always better than cure. And when you have the knowledge, UK law, what is the expectation, what are the arrangements, then you'll be able to ensure everyone is on the safe side. The financial stress is causing a lot of suicidal thoughts to many families. They are under stress, they are panicking, and if they are not emotionally stable, mentally stable, it's going to impact on children. And children are innocent ones, vulnerable. And their schools environment, they are trained to spot any signs. And if such a sign spotted, social service get involved. Many families start panicking. Even police knocking at their door is a challenge to them. Where they come from, they might not have any experience with the social services, they might not have experience with police, but coming to the new environment, trying to balance your life with immigration law issues, at the end of the day, you find yourself in issues around family matter. How do you deal with this? Today, we've got one of our solicitor, Michael Harrison from TSI Law, to bless us, to enlighten us, and to educate us for betterment of these children and our community at large. Please grab a seat. Let's go. Michael, once again, it's a privilege for us to have you around us today. And we say thank you so much. Thank you so much to heed your ears to our cryings of our community that they need help, and putting yourself forward to offer that time. We are not taking it for granted. We say thank you so much. Please take a mic.
Thank you.
Yes, save the woman and the community.
Yeah.
We are here to listen to you.
First of all, can I thank you, Olalarkin, for setting this up, and also to everyone who is participating and listening in to this broadcast. By way of background, I have been a family law solicitor for the best part of 25 years. I've worked in inner cities of Manchester, spending about 10 years working in Moss Side, Manchester in particular. I've also worked for the local authority, and I'm currently head of the family department at Teesside Law. For those of you who have very kindly sent in questions, what I propose to do is to respond in writing and provide written responses to those questions, and subject to consent, they can be shared with the group, because I don't think there's anything of that would cause concern from a confidentiality point of view. What I'd like to start this broadcast is really from this point of view. Each and every one of us has and should have access to fair justice. And what I mean by that is, whether you are going through the court process, whether you are going through the police process, there are provisions for you to be properly represented. If you are in a police station, you have the right to a solicitor. If you are in the courts, you have the right to be heard. And if English is your second language, the court will provide a translation service, because justice not only has to be done, it has to be seen to be done as well. So that's the first thing that I would ask that you take from this broadcast. you do have a right to a fair hearing. And if that right is curtailed in any way, shape, or form, then you can make the necessary complaints, which I think we'll come on to in a moment. So the first topic I want to talk about is marriage and subsequent divorce. Marriage is a legal union between two people. If that marriage is not legally recognised, the marriage will be declared void, i.e., you are unable to marry your sister, your brother, your husband, sorry, your dad, your mum, or whatever. You can't do that. And as such, the marriage will therefore be declared void. If you are entering into a marriage and it's a legal marriage, you do have provision to end that marriage by annulling the marriage and declaring it voidable. That is, the marriage was legally entered into, but now no longer should continue because of a variety of different circumstances, which I don't need to go in for today's purposes, because what I want to talk about is separation and divorce. Divorce is based on jurisdiction. It doesn't matter where you got married, providing you have a valid marriage certificate, you can get divorced in this country, subject to you having habitual residence. Habitual residence is different from a legal
Is it
residence.
not cold upstairs?
Sorry?
Sorry, it's interruption from this. I moved to the person.
Right. All right. Okay.
Apology for that. And also,
No,
let me
it's
use that
fine.
opportunity.
Yeah,
Let me
please,
also use
please,
that opportunity.
yeah, please feel
Let me use
free.
that opportunity.
Yeah,
Let me
please
use
feel
that.
free to jump in with any questions. I'm more than
Yeah,
happy to take questions as we go along.
Michael, 1 minute also. Let me
Mhm.
use that opportunity to also acknowledge the presence of Pastor Lulu. Thank you for joining. I'll make you one of the co-hosts now in case anybody wants to come in. You have access to that, Mama. I'm not sure if Pastor Dan is also in the house. I recognize all the religious leaders in the house. I recognize all the community leaders, both on all our social media. Thank you for joining. And we've got time also to ask questions. So please, let's watch out. Any question on YouTube, any question on TikTok. And if you eventually go back on Instagram and Facebook, please, any question, we also get them. If you're unable to ask today, we are here for you. Thank you. Go ahead, Michael.
Yeah. So, for those who are going through or contemplating a divorce, it is based on the jurisdiction of habitual residence. Habitual residence is very different to settled immigration status. It simply means, where are you living? And either one or both of yous, if you are habitually resident, have jurisdiction to issue divorce proceedings in this country. The divorce process changed 2 years ago to allow no-fault divorces to go through. Previously, it was based on adultery, unreasonable behaviour, 2-year separation, 5-year separation, or desertion based on a period of 2 years or more. Now it's much more simplified. You can simply get divorced on the basis that the marriage has irretrievably broken down. The way in which you would do that is you would petition for divorce, and generally you would do it through the court portal. There is a fee a court fee for issuing a divorce, which currently stands at an eye-watering £596, but you can be exempt from that court fee subject to your finances. You can apply to the court as part of your divorce process to exempt you in full or in part. If you are on benefits, universal credit, for example, you will be exempt from the court fee, but you will still need to make that application. If you are working, the court will ask you to provide your pay slips, and will make an assessment as to what your exemption should be, either full exemption or part exemption. There is a threshold which the court determine. If you are below that threshold, in terms of your income, you will be exempt fully. For every for every £10 you are over that threshold, you would be expected to pay £5 towards the court fee. The divorce petition will then be issued, and then it will be served upon the respondent. Now, this causes some issues because not all respondents will respond to the divorce petition for a variety of reasons, because they haven't received it or out of spite, whatever. The court allow you to get divorced irrespective of whether the other person is in receipt of the divorce petition or not. What you have to demonstrate is that you have made inquiries and attempts to locate your husband and your wife, and then you can submit an application to progress the divorce. So in short, and what I tell my clients is, whether the other side, your husband or wife, participates in the divorce process doesn't really matter. What matters is you will get divorced if you want to. It's just a matter of time, because it takes a bit longer to get divorced if you are dealing with the issue of service of the divorce documents. Once the court are satisfied that either the respondent has been served or attempts to service have been complete, the court will then set a date for what we call a conditional order. That is new terminology for the decree nisi. And 6 weeks after that conditional order, you can apply for the final divorce certificate, which is called the decree absolute. It's designed that way to allow couples who are going through the divorce process time to reflect, to ensure that this big step is something that they wish to continue to take. So you don't get divorced until the very end of the process, to allow a period of reflection to make sure that if you want to continue with the divorce, you are absolutely, you've been given every opportunity to really think about making that big step. The whole process will normally take about 6 months. Could I ask if there are any questions on that before I turn to dealing with the financial settlement following on from divorce?
Do we have any question? Those of you on TikTok, I hope you are hearing us clearly. On Zoom, on YouTube, any question? There's one question here about one of the person I've asked that before, and you mentioned that shortly. The test of financial cost for the divorce payment, legal. You mentioned that if somebody is on a universal credit or this, it can be exempted, but you need to apply.
Yeah.
However, if somebody is not and he needs to request for waiver, they will ask for payslip. Is it payslip they will ask for, or they will ask for both payslip and bank statements, or
Um, um,
outfit?
if you are applying direct to the court, it is payslips and bank statements. They will require your last 3 months so they can do an average assessment of your income per month. You can make a help with fees application via the government website, and you can key in your information, and then you will be given a reference number at the end of that process. And when you apply for the divorce, you can give the court your reference number, and they will then cross-reference that with the application you've made through the government website. But ordinarily, it would be, it's called a form EX160, and that sets out your income, your capital, and they will then annex to that would be your bank statements and pay slips if you are working, and they will then assess your means as to whether or not you are exempt from the full court fee or whether or not you are expected to pay a contribution. That
Thank you for that.
unfortunately doesn't cover legal costs. So just pausing there, about 15 years, about 13 or 14 years ago, the rules for legal aid were changed. Before that, as long as it was a family issue, you could get a type of legal aid, legal help, dependent on your means. That really was scrapped, and the ability to get legal aid was significantly reduced. And divorces are one of those areas of law in which getting financial assistance through legal aid is all but non-existent. So you would have to, if you wanted to see a solicitor, you would have to pay for their services. What I would say is the divorce itself is a fairly straightforward process, save for the potential issue of overcoming service of the divorce document on the respondent. And if you are being charged more than £500 plus VAT for legal fees, I think that is way too much.
Thank you very much, because a lot of people were fearful of the cost implication
Yeah.
and the timing. We will come to the timing later. I think you've covered the timing anyway. The 6 month gap, like
Yeah.
Pastor
Well,
Lulu, have you got any question?
sorry, I was just about to say, so my fees to dealing with a divorce from start to finish are £400 plus VAT. And if people are in difficulty, then they can pay me on a monthly basis.
All right, thank you for clarifying that.
Yeah.
And
I would like to ask a general question if I'm allowed, please.
yeah, take a mic.
Good, thank you so much. And first of all, I want to appreciate yourself for organizing this interactive forum and the presenter for your experience being able to share with us. Thank you so much.
Right.
With that behind us, I would like to ask a general question. As maybe my question is too early to ask, but I would like to ask if by your experience so far, the thing is with myself, whenever I hear divorce, it itches me. I don't like that word for what it means. Do you think the system has any means or any way of discouraging divorce? Do you think the system it can be perceived as either discouraging divorce or encouraging it? Because like every year the statistic goes up, and I'm in search of a measure that the system is bringing in to help people understand each other and a kind of build a family. What's your thought on that?
I think. Well, let me give you an example. When I was working in Moss Side, I was representing a Somalian lady who wanted to get divorced. She was settled in this country, and she sought divorce, as was her right. We didn't have a marriage certificate, so we had to make an application to the courts to get an order for the marriage, for a confirmation that the marriage certificate, sorry, that there was a legal marriage in which to for the basis for the divorce. She didn't know where her husband was. She believed he might have been in Kenya, might have been killed in the war struggles. So we had to make an application for the divorce to progress, and all this took time. She didn't speak English, so everything was had to be translated. But we got the divorce in the end, and she was able to get legal assistance because at the time she was entitled to legal aid before the new rules come in. Now, I don't think the divorce law itself is causing issues in terms of discrimination. I think the rules in relation to funding have been has caused discrimination, because that lady was entitled to get state assistance, some sort of legal aid. Not very much, but she was at least able to. She had a family issue. She was able to see a solicitor. It didn't cost her anything, and she was able to achieve peace. But in the absence of legal aid, I am very concerned about the number of people who are not accessing or seeing solicitors because they are put off because of fees. And I think that may be discriminatory. I don't know the figures, but I would take a view it's probably slanted more in favour of black and ethnic minorities, who and certainly those who are here on potential visa, on various visas. I think those people in the community are certainly put off by going to see a solicitor, and therefore I think this is really important. These types of engagements to say, no, you can come in, we can see you, we can offer free half-hour advice services, we can direct you to the appropriate people, we can help. Does that?
Thank you very much.
Yeah, that's fine.
Pastor Lulu, have you got question? Daniel, have you got question?
Sir. Thank you so much, sir, Mr. Ola, for the opportunity. And of course, I would love to honor Mr. Michael for all that amazing information has been poured out so far. I am on the road, so I won't be speaking right now, but I have invited some few ladies. They're supposed to be here by now, but I've not seen them for us. So I'm just going to send them a quick text and just find out how far they are, because there are some questions. Hopefully, they'll make it on time. Thank you so much, sir. I hand it over back to you.
No, that's fine. Thank you. Do you want me to wait before we move on to the next topic?
Oh, no, that's fine. So I'll just pinch them once they come. I think it was concerning about the social services anyway for them.
Right. Okay. So we've had a situation in which a couple have gone through the divorce process. So what happens next in relation to the distribution of assets? They may own a house together, they may have children together, they may have been working, paying into a pension, they may have a car, savings, etc. the principle in relation to financial settlement is one of fairness and equality. What used to happen, again, about 25 years ago, the law was changed. Prior to the law changing, it was always seen as the person who was going out and earning the wage was entitled to the biggest share. Because usually it was the husband going out and earning the money, and therefore he was entitled to the share, the biggest share. And then the law, quite rightly, changed because that was seen as discriminatory. What price can you put on the wife, the mother, staying at home, looking after the children, sacrificing her career? And I'm using husband and wife, but it's interchangeable, but it's usually that way. What price do we put on her looking after the children, sacrificing her career? Because without her, the husband couldn't go out and earn the wage. And so the law was changed to reflect that. And now it doesn't matter who goes out and earns what. It doesn't matter who, in whose name the asset is. The starting point is what is fair for both parties. The number one priority is the welfare of any children. So the court are very reluctant, particularly if there are small children, to order sales of houses because it's too disruptive for the children. They need, their welfare comes first and foremost. They need a house they need a roof above their heads. They need stability. And therefore the court will very much take that into account. And if the court are of the view that the house should be sold to meet the parties' income and capital needs, then if there is small children, what tends to happen is the court will defer that order for sale until the children reach a certain age to provide them with the security that they so richly deserve. The second consideration would be the length of the marriage. The longer the marriage is in existence, the more likely the court is to reaffirm fairness and equality should be a 50-50 split of the assets. Clearly, if you've only been married for 12 months, there is going to be inequality of the split because of the length of marriage. So in those circumstances, if one party owns a house and he brings that or she brings that into the marriage, and then the marriage is dissolved very quickly, then it's not realistic, it's not fair for that house to be distributed on an equal basis because you've only been together for a short time. But the longer the marriage is in existence, the more likely the court is to order an equal distribution of the assets. And that includes pensions. We have what we call a pension sharing orders. So what that means is it is an order to the pension company to say this pension pot or a percentage of that percentage pot is now going to be transferred to the other person, the wife or the husband. Is there any questions that flow from that brief synopsis of financial remedy law?
I'm not sure whether it's not financial, but it's about disputes of birth certificate, child maintenance, and time spent between both parents.
Yeah, all right. So I'll just touch on that. So child maintenance is for the benefit of the child or children. It is based on residency. The non-resident parent has a duty to provide for his or her children. It does not matter whether they are seeing that child or not, they still have a duty to provide. If they are seeing their children on a regular basis, the calculation will be reduced based on the amount of time they are seeing their child. It's slightly more complicated than this, but if I could break it down to this, if you are seeing your child overnight up to 52 weeks, sorry, up to 52 times a year, so let's say once a week, your maintenance contribution will be reduced by about a quarter. 52 nights to about 110 nights, I think it is, but don't quote me on that. It will be reduced even further. But the principle is the resident parent looks after the children. The non-resident parent should contribute towards the upkeep of that child. And if you go on the government website, or if you type in child maintenance support calculator, there is you will be shown a link which you can then calculate how much maintenance the non-resident parent should be paying based on what you think their income is. The powers of the Child Maintenance Service are extraordinary. They can apply to the courts for deduction of earnings orders, which means if the person is in arrears, they can have an order that their employer has to provide the arrears through the deduction of their income, their wages. And I've read cases in which the Child Maintenance Service have applied and been successful in forcing sale of houses in order to achieve and pay back the arrears that have accrued. Is there any questions that flow from that?
Any question from people on TikTok? Any question on Zoom?
Hi. Sorry, I'm the one who asked the question. I'm currently at work, so you have to excuse me a little bit.
Fine.
So basically, the situation that I'm more looking to get like closer answers to is I spend most of my time with the child, so I get that the child maintenance side of things will be reduced. But it's always the matter of it getting hung over my head. I also put the question of birth certificate, so I don't know what insight you can give me with that.
Sorry, insight into what? You just broke up there, my friend.
Sorry?
You broke up a little bit. Insight into what?
Into the birth certificate. Basically, she signed the document, but she doesn't want to go and hand it in. And on the document, it says that both parents have to go hand in the birth certificate if any changes need to be done.
Yes.
Yes. Now, how do I go about if she refused, but she has signed it? So I don't know what the next step is, sort of thing. Yeah.
So the importance of registration of a child's name is, as a father, if you are on the birth certificate, you acquire parental responsibility.
Right.
Parental responsibility is a legal concept, which means that all welfare decisions, key decisions, require the person or requires consent of everyone who has parental responsibility. A mother automatically has parental responsibility. Father acquires it usually through registration of the birth certificate.
Yeah.
So let's take an example. A mother wishes to relocate and emigrate to the other side of the world, let's say Australia,
Yeah.
with your child. She must have your consent. If she does not have your consent, she has to make an application to the court in order to get an order to allow her to leave the country with your child.
Yeah.
That is the importance of parental responsibility. If there are any issues in terms of registration or the documents, then you can apply to the court under the Children Act for what we call a declaration of parentage. And it will be a declaration from the court that you are the parent of this child with parental responsibility.
Right. Does that cost in a sense of me making the application?
All applications have a court fee, and again, going back to what I said earlier, you can apply to be exempt from that. If you sought legal advice, then yes. What I am proposing to do is provide Ola Larkin with a list of documents and what list of applications, should I say, and what those applications mean. So, for example, a C100 form is an application for you to see your children, and you can download it from this website. So you could provide that to all service users. So if you've got an issue, so if it's a declaration of parentage, you could just scroll down, declaration of parentage, I need this form, and this is where I can get it from.
Thank you for that.
Perfect. Thank you very much.
No problem. So is there any other questions that flow from...
No question yet. You can continue with next session.
All right.
Hello, good afternoon.
Good afternoon.
Yeah.
Go ahead. If you want to have a question.
My question is that, okay, I wanted to ask, during the family assessment with our social worker, so there are some allegations which my husband admitted that he did. But while assessing me, he made mention of the allegation, which I didn't. And I said that, okay, I do this, I did not do that. So in his summary, he now put it there that the mother denied some serious allegation. What can I do in that case?
Right. So what I'll do is I'll just turn my attention now to the law in relation to the children, because that will include allegations of harm and how the court approach that. Would that be okay?
Okay.
Yeah.
Yeah.
All right. So there are two strands in relation to applications involving the children. There is private law disputes, that is to say, private disputes between usually parents. One person is not allowing the other person to see the other person. And then there are public law disputes. Public law disputes are when the local authority are involved. On either case, the welfare of the child is the court's paramount consideration. It is not the paramount consideration of the court to consider the parent's point of view. It is the paramount consideration of the court to deal with the welfare of a child or children, subject child or children who are before the court. The starting point in terms of private law disputes is that it is the child or children's right to a relationship with both parents, not the parent's right to a relationship with a child or children. And the court will further that fundamental right of a child to have a relationship with both parents, subject to being commensurate with the welfare being the primary consideration of the court. It is unfortunately the case that in some situations it is quite right and proper for a father or indeed a mother not to have a face-to-face relationship with their child because they are deemed a significant risk. For example, parents who have a long history of sexual abuse charges. It's quite right and proper for them not to be having a relationship with their children. So what will happen as far as the court process is concerned is if a parent makes an application to the court, that application is automatically sent to what we call the CAFCAS service. The CAFCAS service is the Court Welfare Service, and the Court Welfare Service are effectively the eyes and ears of the court. And they will, prior to any first hearing, will provide the court and the parties with a safeguarding letter. The CAFCAS service, as part of that process, will interview both parents to get their views on the application, but they will also have, more importantly, access to social services files and also police records. Because what we want as practitioners and what we want as judges is we want as much information as possible regarding any potential risk so that we're not making orders that are putting these children at risk. So the safeguarding letter is a vitally important document because it will demonstrate a person's propensity for abuse, violence, because it will show up on his criminal records, whether there's social services involvements and why. Now, I can't, and neither can the court, stop people coming to court and saying, I don't want that person to have a relationship with my children because that person is violent, because he is a sexual risk, and the other person will be saying, that is complete nonsense. That is just simply lies. What the court will do in those circumstances is they will have a finding of fact hearing. The finding of fact hearing will be used to determine whether the allegations are proved or not. And it will be based not on the criminal balance of on the criminal standard of proof. The criminal standard of proof is beyond reasonable doubt. It will be based on the civil standard of proof. Is it more likely than not to have happened? But you are more than entitled as parties to proceedings to challenge the evidence and what is being said, to either prove or disprove any allegations. And the court will determine whether those allegations are proved or not, and that will form what we call a factual matrix for there to be an assessment of that party's ability to care or see their children. Is there any questions that flow from that? I just want to pause there.
There is a question. Someone is at work, just sent a message on WhatsApp now.
Yeah.
Good morning, sir. Imagine my lawyer telling me to accept threshold,
Right.
or I stand a chance of the children not being returned to you.
Right.
After the fact finding. After the fact finding. Because he said that's the judge findings. He said if I accept, they will return the children. But if I did not accept, then I should go and appeal it, and I will not represent you for appeal.
Right.
What,
All right.
what
When we talk
is the
about
chance?
threshold, I think that takes us nicely into public law children matters. This is where the local authority are involved. There are 3 levels of local authority involvement. There is child in need level, in which the local authority are not concerned about your ability to care for a child or children, but rather you need some support, usually getting children to and from school or appointments or whatever. They will provide you with assistance. Secondly is child protection, where the local authority have got concerns regarding a child or children and a family, and they will invite the parents to a child protection conference, and if the children are placed on the child protection plan, the idea behind that is the plan is explained to the parents with a view to them working with the plan, with a view to that plan then being reduced back to child in need. I have to say, I do not like child protection conferences. I think they are borderline cruel, because what it involves various people or professionals who are involved in these families who have no child protection or very little child protection experience, giving a view as to whether or not these children should be on a child protection, the child protection register, and they give their reasons. And the parents have to sit there and listen to a social worker, that's fine, but nursery workers, school teachers, GPs, police, all forming a view based on quite simply what they've read and what they've heard. But that's my own opinion. I don't like them. I don't think they're the best way of dealing with concerns. The third, and more importantly for the purposes of this discussion, is looked after children. Looked after children are where the local authority believe there are significant concerns and they have enough evidence to apply to the court for various orders to obtain, to achieve protection of the children. Before going to court, they will have to go through what we call the public law outline process. That is a process in which they will invite the parents to meetings. The parents can get a solicitor present, that it is one of the areas in which legal aid is available. And they will be saying, in effect, to the parents, look, these are the concerns. This is what we want to do to try and reduce the concerns. If those concerns are not reduced, or then we intend to apply to the court. If they apply to the court, it is under Section 31 of the Children Act, and it is on the basis that they believe threshold is crossed. So when parents talk about, or solicitors or social workers talk about a threshold document, it is threshold pertaining to Section 31 of the Children Act 1989. And that threshold is thus, that this child or these children have or are likely to suffer significant harm if they remain in the care of the parents. That is the threshold which the court and your solicitor will be referring to. And the threshold document will set out the concerns. So it could be anything from sexual abuse, physical abuse, drug issues, alcohol issues, neglect issues. The important thing as far as parents are concerned is it is not up to the parents to disprove the allegations. It is up to the local authority to prove those allegations. So them allegations must be backed up with clear primary evidence as to what the allegations are. Is there anything that flows, any questions that flow from that before I move on?
Any question? TikTok, I've got any question from what he has just explained now?
Hello.
Hello.
Yeah. So thank you, Michael, for the wonderful information. You did mention about, I think, local public hearing or something after the CPC conference.
The Public Law Outline Programme,
PLO.
Yeah.
PLO. So, because I actually have a present case and there was nothing like PLO. The like it was today, let me just use it in this time. Today, I was invited for the children CPC hearing, the conference. I went there. The very next day, they told me they found something on my partner's phone. They found a video, and then we are going to court.
Right.
So there was nothing like PLO the next day. Before I knew it, they just gave me it's like they came to my house in the evening, and by the next day around 1, we're in court already.
Yeah, so the local authority can bypass the PLO process if they are of the view that there is a sufficiently urgent need to protect these children. So they can bypass the PLO process and go to court to get the various orders, which I will now touch upon after we've had our exchanges.
Any question again?
Is there anything, or shall I move on to the various orders?
Before you go ahead, Michael.
Yeah.
From the cases we've handled and with the little experience we've acquired, we believe best interest of a child is for the local authority to provide support for that child to thrive within the birth family.
Yeah.
Now, if there's a referral of safeguarding concern, the policy suggests they need to look for family, friend, relatives, even before asking parents to sign Section 20.
Yeah.
If they cannot provide, they need to sign Section 20. And if they refuse to sign Section 20, they can use police protection power to remove the children.
Right.
But in most cases, as soon as there's an allegation or referral from the school to the social services local authority, parents come back that they said they've removed their children, they cannot even pick their children at school. Many parents drop their kids at school and they could not have access to them after closing hour, and the matter has been to court. Does it mean the right to family birth is not mandatory like relatives?
So first things, Section 20. That's Section 20 of the Children Act 1989, and it provides or allows an agreement between the local authority and the parents for the local authority to place the children outside the care of the parents without the need for a court order. That is its primary basis, Section 20. You are under no obligation as parents to agree to sign Section 20. And if the words Section 20 agreement are discussed with you and a social worker, I would urge you to get on the phone to a solicitor so that can be properly discussed as to whether or not you should or shouldn't be signing a Section 20 agreement. In the absence of a Section 20 agreement, the local authority and the social worker must apply to the court for the appropriate orders. The social worker does not remove children. It is only the preserve of the judge. Only the judge can sanction removal of children from parents' care because it is in the best interests of the children based on the evidence for that to happen. It is a draconian step as far as the court is concerned, and any removal that is sanctioned by the court must be backed up by evidence to support the allegations that require removal of children from parents' care. Now, if you are going through the court process and you have, as one of our delegates have just said, they've ignored the PLO process and gone straight to court, the court will make those orders as a holding position. They will allow the parents then to file responses to the local authority concerns. They will allow expert evidence through applications under what we call Practice Direction Part 25 that governs experts. Those experts can be DNA testing, it can be drug and alcohol testing, it can be experts into psychological issues, psychiatric issues. The court will direct evidence from the police in terms of police disclosure. All the while it is building up a picture as to what is going to, as to the long-term planning for the children. And in cases, unfortunately, it does mean that the children are permanently removed from parents. But in lots of cases, it also means that the children are reunited with the parents because the evidence has come in which would support the parents and not the local authority. And it goes back to what I said at the very beginning. It's access to justice. You have a right to be heard, no matter what your circumstances are, no matter what your cultural backgrounds is. And when the judge is being asked to make a decision in relation to any child, particularly a long-term care planning, the court have to give rise to Section 1.3, the welfare checklist, that's Section 1.3 of the Children Act. And part of that consideration will be the cultural needs of these children. But if you have social services involvement, please, please, please get on the phone to a local solicitor, particularly one who has a legal aid contract, because with social services involvement, because it is the state becoming involved in your life, you have access to legal aid. Is there any question?
Any question before we go forward? Any question on TikTok? Have you got a question there?
Hello, please have a question.
Okay, yes, Bisola, go ahead on Zoom. I will come back to TikTok. 1 minute. Bisola, go ahead.
Okay. My question is concerning the PLO. For example, if you have a child that has already been removed to foster care, but the reason why they claim they removed the child was because the child went to school and said she has been physically abused by the mother.
Yeah.
So the next thing, the social worker came home to meet the mother that the mother will have to leave the house because the child make a complaint that she has been abused
by her. She has been physically abused by the mother
Mm-hmm.
at school. But actually, we did not see any mark on her body, but she claimed that her mother scratched her with nails and hit her with buckle of belts, which leaves marks on her face. But according to what they said, but we have not seen any marks on her body.
Right.
So the mother now said, why will she leave the house for the child? Because she has siblings and she has a baby. So she can't definitely leave the house for the child. Since it's the child that complains about it, then maybe she will be the one to leave the house for the mother, not the mother leaving the house for the child. Then the next thing, the social service went out, came back with the police and arrest the mother. So the following day, they brought a Section 20 for the husband to sign.
Yeah.
In which we give them at the police station when the mother was granted the bail. We actually give them a family member contact in which the child can stay with, since the bail condition said the child cannot stay with the mother. But the social service did not even consider those family members. They only came with the Section 20 form, tell the husband to sign it. And what they said was, in case the child needs any medical attention or something like that, so the dad should sign the Section 20 so that the person that the person that the child will have to stay with, since the mother cannot see the child, you understand, will be able to take the child to the hospital. That was what they said. So it was after signing the Section 20 that they now told the father that they are taking out to for a foster home or something like that, that she will be going there on Monday. Only for 2 weeks, they denied the father the access to see the child. So the dad started writing mails in order to see the child. Only for the dad to see the child, and the child was confirming to the dad that she has actually been with a foster parent here in Luton, which is different from what the social service said. The social service, when they removed the child, they said they have a family, they have an hostel or something like that for her. That is where they're taking her to. But only for the child to say to the father that she is actually living with an Asian parent very close to her school, which is different from what they said. So the dad had to ask them, why would they do that? They said, actually, they believe that one is a long-term placement, but why didn't you inform him? So along the line, they put the remaining 3 children under CPC. Then they went for PLO. The PLO, they had to put the name of the 4 children. But fortunately, during all the PC and the CPC call meetings, there has not been any concerns concerning the remaining 3 children, either from the medical authority, from the school, everywhere. There has not been any concern. So what I want to know now is, if eventually they go to court, probably because of the one that is with the foster care, is it going to affect the remaining 3 children that they have no concerns about?
Right.
Or
so
what should the parents do in this situation?
Right. So let's go through that. I need to be very careful, because if it's an ongoing case, I'm unable to provide tailored advice if people have already got legal representation. But let's look at it from a generic point of view. First and foremost, Section 20. If a parent or parents sign a Section 20, then the timetable for progress is governed by the social worker and not the court. If you are going through the court process, the timetable is governed by the court, having regard to the principle as set out in the Children Act 1989, which is delay is prejudicial to the children. So the quicker we resolve these issues, the better it's going to be for the children. I have come across constantly a lack of delay, a delay process because the social workers have got the Section 20 and they are not doing what they want because of resources. And it's far better to say, I am not, in those circumstances, I am withdrawing my Section 20. And that forces then the local authority to either withdraw or to go to court. If they are going to court, then the timetable will be set by the court and not the social worker. Number two, if there is a dispute as to the evidence, the court needs to consider the appointment of an expert to deal with that dispute. So if there are allegations of physical abuse which are denied, then the court will invariably direct the appointment of an independent expert to provide opinion as to the allegations of physical harm. The local authority are also under a duty to assess alternative family members, because as far as the court is concerned, the court look at it from this perspective. Can I place these children back with the parents? If not, why not? Can I then place the children with alternative family members? If not, why not? And then ultimately it will be long-term foster care or even adoption. But that is basically how the court approach cases. Each child needs are individual. Of course, there are overlaps in terms of the importance of sibling relationships, but it doesn't follow that just because you have had 4, 5, 6 children removed previously because of concerns that your baby will be automatically removed. It's an entirely different set of circumstances and needs to be considered on its own merits. And I have had cases where lots of parents have had lots of children previously removed, but they are keeping the children who are recently been born. And if children are in long-term foster care under a care order, that doesn't stop. So even though the proceedings are finished, that doesn't stop a parent from their right to make an application to discharge the care order and seek the return of the children to their care. Most practitioners do that on a regular occurrence. I lost my children because of drug and alcohol. I've been clean, I've been sober, my contact has been increased, I'm getting on well with the foster carer, and therefore I'm now in a position to be reassessed for the children to be returned to my care. So, again, it just all goes back to the access to justice and the right to be heard, right? What is your view in relation to the allegations before the court? Do you agree? Do you not agree? If you don't agree, then what do you say about it? How do we then move forward in terms of the potential for expert evidence? Does that assist?
Thank you. Yeah, it's fine. Thank you.
Thank you very much, Solid. I think I've probably reached all that I need to say in terms of divorce, finance, private law children, and public law children. As I've said, I'm more than happy to give some thought to questions and provide written responses to those questions in due course. If people want to take time to digest what's been discussed and then come back at a later date, I'm more than happy to provide answers to questions at a later date. I'm more than happy to provide advice for those delegates who are in need of some advice following on from this this forum. Is there any questions before we look to wind down, as it were?
Thank you very much. Anybody, okay, on TikTok, Abon, take a mic. Are you there?
Oh, yes, Mr. Ola, I'm here, but I'm with my boy, as you know.
Yeah, it's fine. You might not.
Yes, sir.
Go ahead if you want to have.
Yeah.
If you have any question.
Yeah, I'm just happy to join this forum. The one who say, I don't know his name really.
It's Michael.
Really Mr. Michael, thank you for your contribution. And then we, the parents, has gone through such a problem with social service, and then we can learn from this. I just want to ask here, a just simple short question. Because he said, if the local authority or the social service do they have any evidence about a parent, and then if the parent don't sign Section 20, and then I believe there is a right for you, your legal aid, to stand for you there, and then make sure you get your rights. Mm-hmm. But if you're working with the legal aid, and then this legal aid is saying that I don't have nothing to say, we just need to listen to the local authority. It that makes sense in your trial, or is that really disappointed from the social worker? I mean, from the solicitor, by saying that kind of word to the parent.
Right. I can't comment on advice from the solicitors. What I will, so in terms of the legal aid, if you, the local authority, are making an application to the court regarding your children, the legal aid is non-means and merits tested. That means you will get legal aid and it will cover all the costs throughout the case. It will cover all the experts' costs throughout the case and all the legal costs throughout the case. In terms of your relationship with your solicitor, it is important that you have a good working relationship with your solicitor. Your solicitor should be providing you with the documents, getting your regular responses to those documents, so your position can be submitted to the court, either through a statement process or by standing up in court and setting out your position. The conversations, and certainly from my perspective, you should not shy away from having robust advice or robust discussions with your client, because sometimes the evidence is overwhelming in some cases to the detriment of the parents. And therefore you've got to have those robust exchanges. But again, to reiterate, these are not our children, they're your children. The court are looking at and determining the long-term planning of your children, not mine. So you can't be passive. You cannot be passive. And I'd be very surprised if you were having legal advice that basically says, just don't say anything. You need to tell me. I don't agree with this. Yeah. Well, and then my question is, why don't you agree with this? And then I can say that to the judge.
Yeah. Because why? As you said, you need to get a relationship with your legal aid, and then this legal aid have been paid for them to represent you, not to control you. And then in the sense, it's like some legal aid. It's like you want to put the right thing to them and tell them, say, look, this is what I'm feeling. This is my family. I want to be there for my family. Yeah. And then the legal aid is still trying to tell you that, look, this is not Africa. This is that. And they said you need to listen to the local authority. They are the one going to decide whether a child going to come home or you work with your social worker. And the social worker is working with the local authority. So it means the legal aid is really, they need to really check on the legal aid because they are taking advantage because of they are working as a legal aid and then they are paid. It's not you are not the one paying them. So it's like the legal aid need to be strengthened, especially. That's what I see that because most of the problems here I'm getting, we don't get a problem with the local authority. If the legal aid go there and say the truth and try to stand for you there and see for you to see justice, I believe that there's no problem going to be with family. Sorry for the noise.
No, it's fine.
It's all right.
I act in accordance with your instructions. You tell me and I tell the court. That's how it works. I'm your mouthpiece. I'm your voice in court. Yeah. That's how it works.
Thank you very much. Abraham, take a mic from Zoom. Abraham, take a mic. Apia, if you want to ask a question.
Thank you, Mr. Michael. Thank you, Mr. Michael, for the insightful and thought-provoking explanations. I just want to ask you how this can be handled, your advice in these circumstances. One, I believe the social works are there to do justice, but in the process of doing justice, if you see blatantly that injustice is being done in the process of doing justice, so what is the justice in the first? What kind of quality of justice is that? I give a situation, for instance, the social work intervene in a family, and now the head of the family is removed from the house, and the allegations are not yet even proven, but the head of the family, maybe the husband is taken away from the house, and then the children are left in the care of only the mother. And these children is not just one child, they have to be taken to school and taken to different schools, and multitasking, and the wife, the woman has a job to do. And because this situation has affected, even the man is not working, and then the woman too, because the husband is not there to support the woman too, is unable to go to work because he has no one to assist. And then we don't have there's no support we're not receiving support from government or anything of any kind. And so in the end, how do this family that the social works are claiming to be helping, how do they want them to cope? They're not getting any benefits anywhere. How do they pay the bills? How do they get food, and how all of this? And all this is put before the social works, and they seem not to care or say anything about it. And it goes on and on and on. So I just want your intervention on this and your best advice in these circumstances, please.
Well, the local authority have a duty to provide an assistance for all children in their care. If you are subject to child protection, part of that plan will be how these children are going to get to and from school, how the mother, who is the primary carer, how is that mother going to be supported to meet the needs of these children. And again, if this is being done under Section 20 and there is not there is clear it is clear that there is a lack of support under the Section 20 process, then we have to have a conversation about whether or not we should terminate that Section 20 agreement if it is becoming significantly detrimental to all parties concerned, but particularly the children. And it doesn't always flow that because you withdraw your Section 20, it doesn't always flow that the court proceedings are issued. Court proceedings are issued on the basis that the local authority have and can demonstrate to the court that there are significant concerns. In the absence of that evidence, they can't go to court. So you're free to get on with your lives without social services intrusion. But it's hard. I entirely get that. It's very, very hard for parents on limited income with no support, with social services involvement. It feels like you are forever on a hamster's wheel. You're just going round and round and round without any plan to end this cycle. And I get that. And if we can assist in any way, shape, or form, then we will do this. I'll give you a personal example. When I was practicing in Manchester, we had our first child in Manchester. Both me and my wife were from the northeast, from the Teesside area. We had our first child. My wife was pregnant with our second child, and we panicked because we didn't have any support networks around us in terms of our family. So two professionals moved to be closer to the grandparents. So I have the utmost sympathy with parents who don't have that support network and are trying to look after children on limited incomes and have the intrusion of social workers, because we moved 120 miles in order to access that network, that family network of support. So from a personal experience and my team, we'll do whatever we can to assist. We really will, because we know and understand how difficult it is for parents, particularly with these days with the cost of living crisis.
Thank you.
No, thank you.
I've got one question here on chat. I don't know whether you have access to it. I want to know how to sue social services. And also, when my sister ran to Ghana, they arrested my dad. He had no idea she went to Ghana. The police put him in the cell for 3 days with no solicitor present, and took him to High Court with no solicitor again. Social services wanted to ask judge to put my dad in prison or to have his passport taken from him. What do I do?
Right. So, number one, if there has been, if you are unhappy at the way the police have treated either your father, your mother, even yourself, if you've been unhappy with the way you are being treated, you can speak to a solicitor who deals with police complaints, and you can present your case through that way. The first port of call in terms of social services involvement and social services complaints would be to write to the social services complaints department to air your grievances. They will provide you with a response, and if you're not happy with the response, they will provide you with an ombudsman, for want of a better phrase. So if you're complaining about a solicitor, you would write to that firm setting out your grievances. They will provide you a response. If you're not happy with that, you can complain to the legal ombudsman. There's something similar for social services. In terms of the court process, again, it's a matter of evidence, and the court will make decisions because they believe it to be A, necessary, but B, proportionate. Yeah. So the court are only going to make orders for surrendering of passports, for medical evidence, reports, for whatever, if the court take the view that it is necessary in order to assist the judge moving forward in decision making, but also it is proportionate to the allegations before the court. So in any issue before a judge, he or she has got to listen to the evidence, listen to the submissions, and then make his decision based on whether any order is both necessary and proportionate.
Thank you very much. Do we have any question again on TikTok, on Zoom?
Yes, I have a question.
Go ahead, please.
Yeah, please. What should someone do if someone is being arrested, as in if someone is being arrested through social service, and the arrest the police made at the person's different address and even different date of birth, but has the same name? What should someone do in such situation?
Sorry, I didn't quite catch that, Bimisola.
The arrest the police made,
yeah,
on the warrant of arrest,
yeah,
it has a different address from the address the person was staying,
yeah.
and even a different date of birth.
Right. Well, I wouldn't know the answer to that because I'm not a criminal solicitor. What I would say is if someone has been arrested, they have a right to be legally represented in the police station. That solicitor, either through the duty scheme or their own solicitor, would then take their case on. And if there's any issues arising, that solicitor with the criminal experience would be able to deal with all matters. We have a criminal department. We go to the police station 24 hours a day, 365 days a week. And then following on from that, if there are any issues in relation to the way the police are dealing with the case, if there are issues of impropriety, the solicitor dealing with that will address that on behalf of the client.
Okay. Thank you.
No problem. Thank you.
Any question? I've got one person that I've put question forward. It's a concern to the person for quite a long time now. But I want to ask Shine, have you got any question on TikTok? Anybody on TikTok? Before we... Yeah, you can ask a question private. Yes, you can ask a question private. I will take it further. If you want to ask a question private, you can still send it further. Those of you that you have put forward your questions before. Sorry, there's a voice from TikTok. Those of you that have put forward question before, Michael has addressed that. He's going to send a written response, and I will share that with whoever send their question forward. So please, Shamin, I will advise send the question on time so that I'll be able to forward it together along with that, so that we'll get response at the same time. Thank you very much, Michael. Just a concern to a community, a family. They drop kids at school. At the time to pick up the children, they said there has been an allegations and the children cannot return to home. Whether the family like it or not, all they have is signing Section 20. Now, they said if they sign Section 20, they won't need to go to court. And because people don't want to go to court, they accepted to sign Section 20. Right. However, they proceed with child protection meeting with them.
Mhm.
On the day of disclosure, on the day of arrest, on the day of referral, the police attended the school and they arrested the parents. And one of the parents supposed to go to work. He could not get access to the workplace, and the phone was collected. He could not message that this is the situation. Because of that, the workplace were frowned at that. On the following day, after arrest, after released on bail condition, she explained what happened to the employer. And the police have also written a letter to the employer to inform them of the arrest and the bail condition, and for the employer to do their risk assessment. The person attended work review on that day, and they told her she can continue her work based on the risk assessment. Within a couple of hours, the decision was changed that actually she's been terminated with immediate effect employment. 3 days after, social services closed the case, no concern, no further action. Police dropped the case, no further action. However, these parents have been dismissed and they were on skilled working visa, which automatically the certificate of sponsorship will be withdrawn. Now, children have returned back. The legal rights of remaining in the country, if there's no other way around, they will have to leave the country or they risk to become illegal. This was due to intervention or involvement of social services, which within a couple of days, the case dropped, no further action. The implication, the consequence of this, who take responsibility? And from the findings, there was no referral to LADO, which it should have been from LADO to the employer. But this was from police to the employer, and employer failed to follow the procedure like a disciplinary, like a suspension, like other alternatives. But this immediately. Who takes the blame? Who takes the responsibility?
Yeah. Well, it seems to me that the first port of call should be to get some advice in relation to employment law, because it seems that you may have a ground for pursuing a claim for unfair dismissal. And again, there should be employment lawyers who will provide half-hour free advice. Again, a complaint to the social worker. I mean, the social worker might be saying, look, we just acted on the evidence because we have a duty to protect all children in our locality. There was evidence that would suggest the children is at risk, and we took the appropriate action following on from investigation. It was found not to be the case, but we as social workers can't take that risk if there is an allegation that we're made aware of, then we have to go and look at it. But certainly, if procedurally there is impropriety that's led to what's just happened, then again, put your grievance to the local authority. But what I'm getting out of these discussions and these exchanges is issues with Section 20 agreements. So before I close this, my advice to you is do not sign Section 20 until you've spoken to a solicitor, because it seems to me that this Section 20 seems to be the root cause of a lot of issues for parents.
Thank you very much. Thank you very much. Just for the benefit of people that are following, some people will say, oh, the parents should have joined union, that union can help, which is supposed to be. However, these parents, they reach out to their union and the union did not even talk about their rights. What the union said firstly was there's employment law. if you have not worked for 2 years, the employer has a right to do and undo. So there's no chance to go for claim. And this is a parent that has worked 23 months and some days. So just few days to be 24 months.
Well, I don't know, but again, there may be some discretion in relation to those dates. I can't answer that. I'm not an employment lawyer, but always seek out some if you've got an issue in terms of your work and your employer, go and see an employment specialist. It's in every solicitor's interest to speak to potential clients. If that means doing it on a half-hour free basis, that most solicitors are prepared to do that. Yeah, because it's in their interest, because quite frankly, they may get some work out of it, you know. So go and speak to an employment lawyer and see what they have to say. You know, there may be some discretions regarding that 24-month period. I don't know, Ala Larkin, honestly.
Thank you very much. This is a very educative, engaging platform that we've really been blessed with your presence. Your expertise has been so helpful. Please, those of you on the Zoom, I know Michael might not be able to see those on the TikTok now and on the YouTube channel. Those of you on the Zoom, if you are able, if you are in a position to open your camera, please. If you don't, I don't know why I put my own camera now. I click it, but it's showing error. Just to acknowledge, just to appreciate Michael, to really say thank you to him. And, you know, if you still have anything to say, we've just got 5 minutes to just round up this session. And those of you that have put forward your question, we'll be taking that forward later as well. We've put some forward, but if you have any additional question, please do reach out on time. Are we there? Are we able to unmute? If you are able to go on camera, please, let's just say thank you to Michael. Anyone there to appreciate on behalf of everybody?
No, thank you. Thank you for your...
Thank you, Michael. Thank you very much.
No, thank you for your time. It's been...
Thank you for your time.
Thank you.
Thank you.
Thank you, Michael.
Thank you.
Yes, Mr. Abraham, please, on behalf of everybody, could you please help us say thank you? If Pastor Mrs. is still there, Pastor Lulu, please, any of you.
Okay.
Apia,
thank you,
the one
Michael.
that want to say thank you on our
Yeah, thank you, Michael. You know, you will not understand what you've done. I don't know, it's a priceless gift you've offered us, because especially those of us who are immigrants in this country and maybe coming from a different background, it's really a battle. And we, from the bottom of our hearts, we say thank you, just like everyone else say thank you. We can't thank you actually enough.
No,
yeah,
it's been a real pleasure.
Thank you.
It's been a real pleasure, and anything I can do to assist,
yeah,
I'm more than happy to help.
We look forward to having more engagement with you, because what I can assure you is that we've not really taken an inch of what we are supposed to address today, but maybe as we create more for our forum to be able to meet again, maybe we'll do much better to address some of these.
I'm more than happy to do more talks and really get honed down on some specifics in relation to various. I've just provided an overview for today to give you some reassurance, but I can provide a more nuanced talk to specific areas of law in the future.
Yeah. So on behalf of all the participants, I'm deeply humbled to be called upon to give their appreciation on their behalf. We, from the bottom of our hearts, we say thank you, and may God be kind to you always, sir. Thank you.
God bless everyone. Thank you.
Amen.
All right. Thank you very much. Enjoy your week, everyone. I'm gonna.
Thank you.
Thank you so much.
Thank you, Ala Larkin. I'll send this over to you when I've had a chance to answer the questions.
All right, that would be grateful. Thank you so much.
Thank you, everyone.
All right, bye.
Good afternoon. God bless.
Thank you. Bye. Thank you, Professor. God bless.
I'm struggling with my network here. Couldn't hand it.
Please, Mr. Laleko, you made mention of a WhatsApp group. How can we have access to
Yes.
that,
sir? Is that Olabi Posse?
Yes, sir.
Did you fall? Where did you fall? How did you get this link?
Because my email address is registered with the group, so I automatically got
your email address.
Yes.
Send me your WhatsApp
sir.
number.
Okay, sir. Should I send it now?
Send me your WhatsApp number through the email. Yes, send me.
Okay. Sir.
Yes, send it now.
Through the email.
So
should I send it on this?
Family, we have the family. Email.
Okay,
Respond
sir.
to the email you receive. Respond to the email you receive.
Okay,
Pastor Mrs. Lulu, thank you so much.